The Bogosity Podcast, early and ad-free. Become a subscriber at Patreon, Subscribestar, or Discord. Use the links at donate.bogosity.tv.
Welcome to the Bogosity Podcast for the week of September 15, 2024. The podcast that doesn't hate you because you're beautiful. This is your host, Shane Killian. Let's runsonate the news of the bogus. Is Texas about to execute another innocent man? 20 years ago this year, Texas executed Cameron Todd Willingham based on non-science and nonsense, which made prosecutors claim that Willingham had set the fire that killed his family, when basically every expert said otherwise, including the Texas Forensic Science Commission and the Corsicana Fire Department. It was Governor Rick Perry that ended up replacing 3 of the 9 commission members to change the commission's findings to support the execution. They also used the fact that he refused to submit to a polygraph, which is complete and utter pseudoscience, as a reason to execute him instead of giving him life in prison. Now, a Texas appeals court has denied a stay of execution for Robert Roberson, who is scheduled for execution on October 17th and will become the first person in the U.S. to be executed based on the pseudoscience of shaken baby syndrome. Roberson's daughter had died, according to him, after falling out of bed in the middle of the night. He was able to calm her down and get her back to sleep, and he thought she was all right, so he went back to sleep. When he awoke, she was blue and not breathing, so he took her to the hospital, where she was declared brain dead and taken off life support. Prosecutors said that it was evidence of shaken baby syndrome, now called abusive head trauma, or AHT. But the science on this has evolved in the last 20 years, and now the daughter's symptoms aren't compatible with that. Additionally, his lawyers uncovered previously undisclosed medical records, a blatant Brady violation rising to prosecutorial misconduct, proving that she actually died of viral and bacterial pneumonia, not shaking or abuse. One of the people who believe firmly in his innocence is Brian Wharton, the police detective who initially arrested him and who's now a Methodist minister, saying, quote, "It's absolutely insane that this never came up in his trial. I've now come to understand that Nikki was a very sick child, and that some of those medical issues could have very easily played into the injuries that ultimately killed her. And shaken baby syndrome, it's been substantially discredited by many in the medical community. Not only is there reasonable doubt that Robert did do it, there is unassailable doubt that Robert did do it." But as he explained, it was the fact that Roberson was autistic that led them to conclude that he was unemotional. The Texas Court of Criminal Appeals is the court of last resort for criminal matters. They didn't even consider the evidence. They just found that procedurally there was no standard for filing a writ of habeas corpus with no review on the merits. According to Roberson's lawyer, Gretchen Sween, quote, "It took years of fighting to get complete medical records. We are devastated by this staggering development, but will continue to pursue any avenue to make sure that Mr. Roberson is not the first person in the U.S. executed under the discredited shaking baby hypothesis." It can be difficult to defend someone against pseudoscience like AHT because there's no mechanism linking the shaking to the injuries. That means it's difficult to present alternatives to the jury, especially without other evidence, such as, in this case, the pneumonia, which can also cause many of the symptoms of AHT, such as retinal hemorrhages or subdural hematomas. In fact, 33 parents and caregivers in 18 states who were convicted of murder based on AHT have now been exonerated, according to the National Registry of Exoneration. And others are on the way, such as a Nashville man serving life prison, but the medical examiner in the case has now recanted his testimony, and the Nashville DEA is seeking to overturn his conviction. The Michigan Supreme Court recently overturned such a conviction and ruled that the defendant deserves a new trial. Same with 2 other cases in Ohio. The New Jersey Supreme Court is now considering whether AHT evidence should be allowed in courtrooms at all. The trial judge in the case called AHT, quote, an assumption packaged as a medical diagnosis, unsupported by any medical or scientific testing. And the state appeals court said, quote, the very basis of the theory has never been proven. None of that moved the Texas Court of Criminal Appeals. His only hope now is a pardon from Governor Greg Abbott, who has previously referred to the death penalty as, quote, Texas justice. So, good luck with that. How can anyone in good conscience execute the man after all this? As for Wharton, he's now turned against the death penalty entirely, quote, we as human beings are incapable of producing the kind of fairness and justice required to take someone's life. We can't do it. And since we can't do it every time in the same way, justly and fairly, then we don't need to be doing it at all in the United States, and certainly in the great state of Texas. We need to abolish the death penalty. Right on, Wharton. The death penalty needs to be ended once and for all as a completely barbaric practice of a bygone age. What is it about statism that takes away your empathy and sense of responsibility? Oh, well, all the proper procedures were followed, so we have to kill him. Too bad he's innocent, but there's nothing we can do. I mean, seriously? If you're looking for a way to support this channel, but you don't have any spare cash and you can't stand ads, you can do so by generating your own cryptocurrency. Use the links at the bottom of the description to follow the link to Odyssey.com to listen to the podcast and see all of my YouTube videos as well. Just watching videos will produce cryptocurrency for the creator and yourself. And since Odyssey is always monetized and never censored, you'll have no problem seeing all the videos from your favorite creators. You can also use the library credits you created Odyssey to tip creators and even purchase paid content. Earn library credits through various rewards, including daily view rewards and the number of shares and invites. And you can interact with creators in all sorts of ways, including like and dislike, comment, boost a post by supporting it, repost it, and share to other sites, all while earning crypto for the creator. Easily monetize yourself and your favorite creators using cryptocurrency, without advertising. Use the link below to visit this channel on Odyssey.com and see many of your other favorites there as well. You know, the more I see of Congressman Thomas Massie, the more I like him. We've covered before how states keep pussyfooting around with our rights that they supposedly agree with, like my home state of North Carolina, where Republicans repealed the insane handgun permit law but then refused to pass constitutional carry, saying basically, that's enough of your rights for now. Massie has introduced a federal act that would do it all in one fell swoop. H.R. 9534, the National Constitutional Carry Act. He said on his congressional page, quote, I'm fortunate to live in a state where people are free to exercise their right to keep and bear arms without begging the government or paying a fee. Unfortunately, not every American enjoys the same right to carry firearms in public because some states and localities infringe upon this right through a variety of criminal, civil, and regulatory penalties. By prohibiting state or local restrictions on the right to bear arms, H.R. 9534 upholds the original purpose of the Second Amendment to ensure the security of a free state while safeguarding individual liberties against government infringement. The bill says, quote, any state or local restriction on the right of American citizens to keep and bear arms impairs the ability of the Second Amendment to achieve its textually specified purpose, the security of a free state. The bill would amend U.S. Code Section 927 to read, no state or political subdivision of a state may impose a criminal or civil penalty on or otherwise indirectly dissuade the carrying of firearms, including by imposing a financial or other barrier to entry in public by residents or non-residents of that state who are citizens of the United States and otherwise eligible to possess firearms under state and federal law. It declares that any laws to the contrary have no force or effect throughout the 50 states, the District of Columbia, the Commonwealth of Puerto Rico, and other territories of the United States. Hunter King, Director of Political Affairs for the National Association for Gun Rights, whose organization supports the bill, said, quote, "Currently, 29 states have adopted constitutional carry laws. Yet, contrary to the warnings of gun control advocates, there's no evidence of rampant violence or Wild West scenarios. Instead, crime rates either remain stable or show a decline. With numerous states affirming citizens' right to bear arms without excessive government regulation, it's about time Congress follows suit." Patrick Parsons, Executive Vice President of the American Firearms Association, another supporting organization, said, quote, "For the past 15 years, anti-gun liberals have told everyone that states passing constitutional carry would experience violence like we haven't seen since the Wild West days. 29 states have proven them wrong, all while gun control strongholds like D.C., Chicago, and California have descended into violence and deadly chaos. AFA is proud to support Congress Massie's efforts post-Bruin to help restore Second Amendment freedom to those across the country currently being deprived by their tyrannical governments." This bill shouldn't even be necessary, as Massie said on X, quote, "No one should have to beg the government to exercise a constitutionally protected right anywhere in the country." And it seems to me there are a lot of amendments that could use this treatment. If you're on the Wi-Fi in a coffee shop or hotel, anyone on that network can get your traffic. Do you really trust all of those strangers? For that matter, do you really trust your ISP? A VPN can protect you from prying eyes, disguise your location, and even foil government censors. It's essential in this day and age, so go to vpn.bogosity.tv and you'll be taken to BoxPN. Starting at just $2.99 a month, you can get unlimited high-speed connections to VPN servers all over the world, and they don't log connections, so your privacy is assured. Traveling abroad, just VPN home, and don't worry about what those other governments are doing. Back at home, stop your ISP from traffic shaping and messing with the quality internet access you're paying good money for. You can connect from multiple machines at once, including your smartphone or tablet, and it supports all the secure standards, including OpenVPN and SSTP. Bypass censors and surveillance with your own secure VPN connection. Go to vpn.bogosity.tv. You're a pain patient. You're invited to join a study about opioid use, and you sign up. Do you expect to be deceived? Lied to? Do you expect the whole thing to be a ruse to try and put even more restrictions on how you can manage your pain? That's exactly what happened in a study conducted by the University of Texas Medical Branch. Participants were given special pill bottles, which they were told was to regulate temperature and humidity inside the bottles. They were also told to keep a daily diary of their medication use. In reality, the pill bottles were really to determine when pills were removed from the bottle and how many. Lead author David Houghton said, quote, "The study involved incomplete disclosure and deception, as participants were informed that the purpose of the study was to test a new prescription bottle that will monitor the physical environment inside the bottle. Participants were not informed that the bottles would record the number and timing of pills dispensed." Amazingly, this passed the ethics board at UTMB, but the deception was just beginning. As published in the Journal of Pain Research, the study found participants who received MEMS demonstrated highly heterogeneous dosing patterns, with a substantial number of patients rapidly removing excessive amounts of medication and or stockpiling medication. By comparison, physicians rated all participants as either totally compliant or mostly compliant. Several sharp decreases in medication supply over short time periods were observed, and a substantial portion of participants ran out of medication before 30 days had elapsed. These data could reflect overconsumption or diversion of medication. Or it could reflect patients putting pills into their weekly pill organizer, as so many of us do because it's by far the best way to keep track of what you've taken. Every several days, we take out a bunch of pills to put into the organizer, which apparently is stockpiling. And they didn't even seem to get the clue with this finding. Quote, data from several participants showed lengthy time periods in which no medication was consumed, thus indicating decreased need for analgesia than is being reported to their physician. Or they were just taking it from their pill organizers. And weirdly, quote, there were additional notable instances in which participants added medication to the bottle, which may reflect stockpiling of medication. So, taking pills from the bottle is stockpiling, putting pills back in is stockpiling. Morton's Fork, anyone? Of course, it could just be that they were going somewhere for a day or two, and, as we all do, we put pills in a planner to take with us instead of lugging the entire bottle around, then put the rest back in when we return. And even when they discussed, rather pathetically, benign reasons why this might be, the use of pill organizers and day planners wasn't even considered. These people either have no clue how people take any regular medication, not just opioids, or they are liars. Also, 25% of participants tested negative for opioid metabolites in urine tests, suggesting that they may have been hoarding or selling their opioids instead of taking them. Or it means they just don't stay in your system as long as advertised, as we've already covered several times. And they really seem to be setting up to blame the physicians again. Quote, overall, physician reports conveyed strong confidence that patients were either totally compliant or mostly compliant. Consistent with our predictions, physicians' perceptions of patient adherence did not align with other adherence monitoring measures. Yeah, it's their fault. We probably need the DEA to raid them or something. Also, consistent with our predictions? Consistent with your predetermined bias, you mean? You did bad science, starting with a conclusion and finding the data to support it, instead of the other way around. By the way, this active group consisted of just 18 patients, way too small to have any reliable findings. It could just be artifacts in the reliability of metabolite detection in the first place. In reality, diversion of prescription opioids is rare, only 0.31%, even according to the DEA's obviously inflated figures. And that figure was used to justify further cutting the supply of prescription opioids in 2024. And that gives us another reason for stockpiling. According to a survey by Pain News Network, out of 3,000 patients they surveyed, much higher sample size than this study, 32% said they hoarded opioids because they were worried about future shortages. Here we have what we generally see in opioid use research, starting with conclusions that justify government crackdowns, then drawing those conclusions from very scant evidence. But then, if they didn't do that, they couldn't support the war on drugs at all. Do you have children, or nieces or nephews? Are you homeschooling, or just want to counter some of the socialist indoctrination most children get in school? If so, go to Bogosity.tv/TuttleTwins, and you'll be taken to a website where you can get some great books for elementary-age children. The Tuttle Twins books are books about liberty and free market economics that include children's versions of Bastiat's The Law, Leonard Read's I, Pencil, and Hayek's The Road to Serfdom, as well as books about the Federal Reserve and how regulations protect business cronies. They'll learn about the harm caused by eminent domain, or regulations passed in the name of safety, and fundamental concepts of liberty. And as you can see from the sample pages on the website, they're all easy to read and nicely illustrated. They're just $9.99 a piece, or get a special discount as well as free bonuses when you purchase all 5. You can even buy in bulk to donate to schools and local libraries. So get the Tuttle Twins books at Bogosity.tv/TuttleTwins. And now it's time to overpronate this week's biggest Bogon emitter. And once again, since no one else seems to be covering the AI cases, I guess it's up to me. And this latest from Richard Kadrey, Sarah Silverman, and the other plaintiffs against Meta just shows everything about how bad their case is. As we covered in the past, they're playing the delay game with Discovery, and now they've asked for another 97 days for them not to comply with it. We've got the judge's order, but before that, let's cover Meta's response brief where they point out all the problems with it. They filed, Meta has cooperated fully and complied with all deadlines, contrary to plaintiffs' unfounded attacks. In contrast, plaintiffs have failed to diligently prosecute this case at every turn. Moreover, according to a proposal sent to Meta today, which Meta opposes, plaintiffs intend to seek a massive expansion of the depositions available to them from the default of 10 depositions to 35 depositions or 180 deposition hours without any justification and despite having taken 0 depositions to date. Plaintiffs' efforts to massively expand discovery through extending the case schedule, all in the face of their lack of diligence and lack of any need, should be rejected. This has been going on for 10 months after the court opened discovery on the one claim that actually survived basic scrutiny. As we covered, the judge threw out all the other claims, bogus stuff like how the model had compressed copies of their books, and the one remaining is that they illegally downloaded their books to get the training data. As the Authors Guild cases against Google Books and HathiTrust showed, if the use of copyrighted material isn't infringing, such as to make a searchable index in the case of HathiTrust, or a digital archive in the case of Google Books, then it doesn't matter whether or not the books were obtained with permission. In other words, downloading copyrighted material is only illegal if it's then used for an infringing purpose. The question then is AI training derivative or transformative? I think our previous coverage shows it's definitely transformative, but this is the one charge that Meta didn't ask to be tossed because they specifically wanted to litigate it and get an answer from the courts. Meta gave references that showed they complied with all discovery deadlines and said, quote, in contrast, only one plaintiff produced any documents on April 1, and plaintiffs waited until after July 15 to produce over half of the approximately 1,223 total documents collectively produced by plaintiffs to date. Likewise, after plaintiffs' demand for a date for Meta to serve its privilege log, Meta proposed August 30 for mutual exchange. Meta served its complaint privilege log on this date, but only 2 plaintiffs have served logs. It was a similar situation regarding depositions. And all of that, Meta argues, means they failed to exercise due diligence, which is required for a time extension. Quote, plaintiffs' distortions of the record should not be permitted to mask their actual improper objectives in seeking to extend the case schedule. Despite that the case schedule has been in place since January and that they have had Meta's custodian since May, plaintiffs only began raising their shifting proposals for expanding discovery in late August. Plaintiffs' motion also fails to forthrightly disclose the massive nature of the discovery expansion they are seeking, as well as Meta's opposition thereto, and perhaps understandably so, as there is no basis whatsoever for their request. It is no secret that many individuals at Meta work on large language models, and plaintiffs' curiosity, without any showing of need or diligence, does not warrant expanded discovery or an extension of case deadlines at the 11th hour. Plaintiffs have not taken their discovery obligations or the deadlines in this case seriously. Because they have not shown good cause, the motion should be denied. Judge Thomas Hickson agreed. He ruled, if the fact majority cutoff were months away, then the court might agree with plaintiffs that Meta's motion is premature. But here we are with 19 days left to go under the current deadline. Plaintiffs do not dispute that the requested documents are relevant and that they agreed to produce them. At this point, Meta is entitled to an order. These requests seek fact discovery that is relevant to damages. There is nothing wrong with that. Plaintiffs have to comply with the documents and information available to them. Their obligation with respect to the RFPs is simply to produce the responsive documents that are in their possession, custody, or control. Hickson granted the motion to compel, and plaintiffs have to respond by the 30th. After he ruled, there's a flurry of letters and briefs which I won't go over, but it got the plaintiffs salty. They're now claiming it's irrelevant, work product, and opinion. They do not want to turn over any of this information or admit that there's nothing to turn over. Remember that they have to show damages. If they can't, it's game over. So then Hickson had to rule. It is sometimes said that timing is everything. Well, it turns out that's true for bad timing as well. Plaintiffs request that the court allow them to take 35 party depositions, and they made that request, 18 days before the current close of fact discovery. Since plaintiffs have taken 0 depositions, the 35 party depositions would all have to occur in the second half of September, which is obviously impossible. Therefore, plaintiff's motion is denied. And in the next ruling, he said, quote, "This is a strange discovery dispute." So, he said, he'll just tell them what their legal obligation is, and that is to produce the documents. And after they whined that means they'd have to produce documents after plaintiffs have been deposed, Hickson said, quote, "That's why you shouldn't wait until 18 days before the close of fact discovery to move to compel on an RFP you served 8 months ago." Man, they are not endearing themselves to the judge. So all of that makes Kadrey, Silverman, and the other plaintiffs this week's biggest Bogon emitter. I want to tell you about the eyeglasses I've been wearing for years. As people can see on my videos, I have a very strong prescription, which makes glasses more expensive, especially when I need computer glasses, reading glasses, prescription sunglasses, and most expensively, progressive lenses for general everyday wear. To save money while still getting quality glasses, I get them from Firmoo. In fact, I just got a pair of progressives with high-index aspherical lenses and a nice pair of frames my wife loves for just over $100. It would have been $500 to get them through my eye doctor. Not only do they look good, the glasses are durable. I've worn many pairs for several years without problems. All orders come with a 30-day return policy, a 3-month warranty, and one-on-one customer service. Go to Firmoo, that's FIRMOO.Bogosity.tv anytime you need quality glasses at a low price. Once again, that's Firmoo.Bogosity.tv. And now let's subspecialize this week's Idiot Extraordinaire. And this week it goes to Senator Marco Rubio, who decided, in true Republican fashion, to ban things because they're sorta Chinese. Contemporary Amperex Technology Company, or CATL, is that pronounced cattle? I'm going to pronounce it cattle, is a Chinese battery manufacturer that makes lithium-ion batteries for electric vehicles and energy storage systems. Globally, they're the biggest EV battery manufacturer with a market share of 37%. But only some of those batteries are made in China. Okay, probably most because China has a booming EV market, but they also have facilities in Germany and Hungary serving the EU. GM is currently in talks to have CATL build a factory in the US to supply batteries for their EVs. Just imagining what Midjourney would make of that last sentence. But, just in case you thought the TikTok ban wasn't stupid enough, along comes fear-mongering about China's batteries. It actually started late last year when Duke Energy disconnected their CATL batteries for fear of espionage. And now, a coalition led by Marco Rubio is trying to get CATL added to an import ban list because they think batteries can be used to spy on you or something. Also, something forced labor. The latter is a joke, as they've already been shown to comply with international regulations in that regard, but that still leaves the first one, which is just unbelievably dumb. Rubio wrote, Not only has Congress repeatedly exposed cattle's nefarious activities in the United States, DoD has sounded the alarm on the dangers of cattle operating on military bases due to the company's deep ties with the CCP. Cattle's placement on the Section 1268 list is long overdue and justified. He compared cattle to Huawei, which makes phones and other devices that were shown to be collecting user data and sending it back to a central server. Quote, Huawei, like cattle, was built as a champion for the CCP, and Beijing acted to support its success. Like Huawei, the presence of cattle in U.S. energy infrastructure raises alarms about the known security risks associated with Chinese technology produced by companies operating under the direction or influence of Beijing. Cattle could introduce malware into large-scale power storage stations, threatening the U.S. energy grid. Further, the significant known cyber risks to BESS systems more broadly, such as security limitations that prevent regular updates and gaps in reviewing vulnerabilities, raise several concerns that a malicious actor or government could seek to exploit. If you're wondering how batteries can do all of that, well, they can't. They're batteries. And yes, there's smart everything these days, but the smarts aren't part of the batteries themselves. Journalist and financial advisor Bradford Ferguson explains in a thread on X, quote, the use of batteries is not a national security risk. Batteries enhance national security by making us less reliant on oil. Batteries are a dumb technology that slot into smart technology. The smart technology tells the batteries what to do. Cattle doesn't control or have a kill switch on the batteries. Marco Rubio is pure big oil fear-mongering. It would be a huge setback to Tesla's Megapack efforts, which are a national champion/treasure. The Tesla Megapack uses cattle batteries, but Tesla controls the batteries. In my opinion, Rubio doesn't care about national security. He cares about special interests, big oil, and defense. The smart part is a BMS, battery management system. In large setups such as EVs and power storage systems, the battery doesn't do that. The BMS is integrated into the system itself. In the case of an EV, it's firmware or software in the EV so that the EV can manage the charging and discharging of the battery through the CAN bus. It just can't do that if the smarts is in the battery itself. While there may be some smarts in the battery pack, such as the monitoring of independent cells or blocks of cells, it doesn't actually make the car do anything or have any way of reporting back to China or wherever. Imagine the disruption to the economy in so many markets if government adopted a from China therefore bad policy, but that seems to be what Rubio wants. At least, about the things that compete with his interests. His main supporter is billionaire Norman Brahman, who makes his money selling traditional ICE cars. Look, we get it. They're a threat to your interests. You're hardly the only politician that does this crap, but usually they come up with something that's not completely brain dead. So all that makes Marco Rubio this week's Idiot Extraordinaire. Well, that wraps up this First Things First, but not necessarily in that order, edition of the Bogosity Podcast. I hope you enjoyed it. If you did, please go to donate.bogosity.tv for several ways to support and discord.bogosity.tv to join the discussion. Subscribe at the Discord or at Patreon or Subscribestar, and you can listen early and ad-free. Thank you for listening. Until next time, here's a quote from P.J. O'Rourke. Republicans are the party that says government doesn't work, and then they get elected and prove it. The Bogosity Podcast is licensed under Creative Commons Attribution, Non-Commercial, No Derivatives 4.0 International License. Bogosity.